Estate planning isn't scary, but not having something in writing can be terrifying. So for the month of October, I am going to do a series of estate planning horror stories. So here we go. So here is our scenario. We have mom, who's a widow, and she has 3 daughters. Daughter 1, daughter 2, and daughter 3. Daughter 1 lives out of state. Daughter 2 lives in the same town as mom. She has her own kids, she has a busy life, she has a job, and she's struggling with finding time to see mom, so there is a strained relationship between them. Daughter 3 lives in the same town with mom as well. She's not married, but she has a gambling problem, she cannot hold a job, so she's struggling with making it day to day. Mom sees one of our educational videos and decides that it's time to sit down and work on her estate plan. But when it's time for her to choose who would be in charge of her estate, maybe a personal representative or a trustee, she has a hard time deciding. The daughter who lives out of state, daughter 1, may not be the best choice. Daughter 2, while she is responsible, she has her own family, her own things to take care of. Mom absolutely knows that daughter 3 cannot be trusted. So while she's thinking about all this and wondering who should choose, what other options are there, what's the best way to go about it, before seeing an attorney, mom gets into a car accident and becomes incapacitated. So here is the horror story part. Because there's nothing in writing, mom has no power of attorney, no trust, someone has to go and file for an adult guardianship proceeding and ask a judge to allow them to make medical decisions and to access bank accounts and pay bills and such. The only person who's around and available and interested is daughter 3, whom we know now that she's not the best choice. She goes in front of a judge and says, mom is in a car accident, here is the record, and the judge appoints her in charge of mom's financial and medical affairs. But let's say daughter 3 does not have a gambling issue, but she has different beliefs than her mom. So even though she knows that mom would have wanted certain things, she's not ready or willing to follow what mom would have wanted. Or let's say that when daughter 1 and daughter 2 learns that daughter 3 is trying to file for guardianship for mom, they hire an attorney as well and they go to court and contest it. Imagine the expense and the conflict and the tension in the family. All that can be avoided by having something in writing, by having a power of attorney in place. I cannot stress it enough how important it is to have a power of attorney in place. You should be the one choosing who should be in charge if you become unable to make decisions. Not only because you don't want your family to go through a guardianship proceeding that could cost thousands of dollars, time off work, and conflict between family members, but because you want to choose. You know your family best. You know who will be able to properly manage your affairs and to make medical decisions as needed. The cost of a power of attorney, the cost for the entire estate plan, including a trust, can be less than the cost of a guardianship proceeding. So don't wait while you have capacity, where you are well and healthy. Give us a call and schedule an appointment. 405-857-8231. Thank you for watching.